Good morning, you're Mark Ramirez. Give me just a second. And Mr. Ramirez, this is your initial appearance in cause number 25 DCCR 1362. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 24th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, I talked to one, I forgot his name, I'm bad at names, but they said that they were gonna appoint.
Speak up, please.
They said they were gonna appoint one because my fiance talked with the DA and with the Keith guy, and something about trying to get a dismissal on the recommendation on my behalf, or if he's a see if I can get that person.
Okay, so who's your girlfriend? Is that Patricia Zamora?
Yes, ma'am.
Okay.
She was outside, but they didn't let her.
Okay, you do understand that there's a no contact according to your bond at this time?
It was set by the judge in Jefferson County for last month that it was how you say it was lifted. It was lifted last month.
Who lifted that?
I got the paperwork from the judge.
Well, but regardless of the protective order, there should be a, yeah.
Yes, ma'am. They lifted the protective order.
No, I'm not talking about the protective order. So a condition of your bond is that you not have contact. So there's two different things. There was a protective order that lasted a certain amount of time. That's over, the emergency protective order. However,
So I guess they never told her that either.
well, they don't have to tell her that. It's you. Hold on, I'm looking at some paperwork here. Okay, were you also arrested for driving while intoxicated at some point?
Yes, it's different.
So the magistration paperwork that's in the aggravated assault case is the DWI paperwork. Let me see. No, because it's got the interlock and May 24th. No, 2 different days.
It happened like in the 2 weeks prior in the same.
Do you have the auto ignition interlock device on your vehicle? Okay, if you'll make a note for Christy, I need the magistration paperwork for, can you just have a seat real quick, guys? I want to see the paperwork just to make sure that all the bond conditions are what they need to be on the correct case. So don't leave the courtroom, just have a seat for a minute. Is she here? Okay. Part of what I tell you to do, but what I am going to tell you is you probably can hold off on hiring someone. If everything goes well, you adhere to the bond conditions, she takes the class, then at some point it looks like your case will probably be disposed of without the necessity of you hiring an attorney. It probably isn't a bad idea for you to start looking at least. And obviously I understand that you guys, it looks like you're trying to work things out, but you're gonna have to not do that for some short amount of time.
Okay, I've been going through issues. Illnesses and everything, and then I took in her son at 5 months old because the father left, and I'm the provider of the house. And she don't have a job; she's a full-time mother, and I'm the one that pays for all the bills, all the food, everything.
So here's the thing, it's a second-degree felony. All I know is what you're charged with is serious, and I cannot feel comfortable without more information or some type of hearing. Now, if you want to go hire a lawyer, and they can file something to come in and have a hearing where everybody has notice of it, the district attorney can put on any evidence. If she wants to show up, she can. Then we'll discuss it at that point. But the only way to get that done is going to be probably to get, let me see, who's his court appointed? Who's his court appointed? I got it. Mr. Parker, Mr. Parker was appointed to represent you while you were in custody. He is still your court-appointed attorney. Talk to him about all of these issues. He can file something, we can have a hearing, have her here, and then I will consider lifting that no contact. As of now, it's a no contact. So,
Pastor, he can do it, Pastor, we can,
well,
I'm just trying to go.
nothing's going, listen. You see how many people are in here today? I have that many people every day. I understand you've got a lot of issues. I'm trying to help you out. Talk to Mr. Parker. You have a no contact as of now, period. Step in front of the clerk, she'll give you a reset notice. In cause number 25 DCCR 1362, that is the aggravated assault with a deadly weapon. And if there was not already a condition of your bond that you not have contact with the complaining witness, which I believe there probably was, then I am imposing that condition now. I understand she's out there. Y'all need to figure out different places to live, different things to do until your case is resolved. Do you understand? That means no contact in person. It also means no communication. If she wants to discuss with the assistant district attorney or the district attorney an affidavit of non-prosecution or things like that, she needs to do that separate of you. You need to still go get an attorney.
She already did talk to the district.
Okay.
January the 8th, she starts the class.
She's going through the options class. Okay.
And that's why she told me that this court date was supposed to be.
Well, nothing gets dismissed until she completes that class. Okay, and so what they do is she goes through that class. If she still feels that that is what she wants to do, she will let them know that, and then that happens after the class.
Okay, so I'm going to bring you, I had a good job, and with this case pending.
Okay, the case is, there's nothing I can do about the case pending. So your case is pending until it's resolved one way or the other. If that's, I understand, and it's also the time of the year where things go a little slower, like the options class isn't being offered till January and things like that. None of that changes what I'm going to set as your bond condition, which is the no contact order with her, okay? You need to, I'm going to reset your case to give you some time to see if you can get someone hired. If you get a lawyer hired before the next court date, bring the reset notice that you get today. They'll tell you what to do. If you're unable to hire someone, you need to talk to at least 3 lawyers and then bring me who you're talking to and we'll discuss your options. And then it might just take a couple of resets of this. If she goes through that class and the case gets dismissed, then you may or may not really need one, but I want you to be working on it just in case.
So I'm going to ask if I did hire one, and it does get dismissed all of them.
That's between, well, and so I typically wouldn't say that this. Ms. Malfino, do you guys have a way to check and confirm that someone has at least signed up for an options class in January?
Yes, ma'am. What's the
It's,
name?
what's her name?
Patricia Zamora.
Patricia Zamora on a January 8th. If you'll just double check that for me. Okay, have a seat again. Okay.
And it's in the bond conditions that there was no contact with her name.
Okay.
It says it in the
Just
thing,
saying,
so.
well, okay, I'm gonna hold on to this for a second. Okay, so the test was negative. Mr. Ibarbo, you wanted to say something, sir?
You could address the court.
Yes, sir, I'm just, y'all are probably an alcoholic drug addict my whole life. I went through treatment. I reached a point when this case came about, everything, my whole life, the futility of it all was overwhelming. And, anyway, so I've been cleaning souls since July the 8th. I go to AA regularly. I like it. It's where I belong. I've got a sponsor today. I'm working the steps. I'm just on step 4. It was where I found a purpose that I've never had. And I think I could do well on probation. And, hopefully one day save somebody else from living another day, you know, what I've lived. Which is horrible addiction. Now that's all about it.
Thank you, sir. Mr. Coleman?
Judge, I'll be brief. I think the PSI speaks for itself as far as criminal history. I would like to add I have judgments here. I've made them available to Mr. Kimler for additional convictions that were either not included in the PSI or they could not confirm those. And for the record, Judge, I am speaking of a 2013 aggravated assault out of St. Charles, Louisiana, in which the defendant received a 6-month probation. Also, a 2008 possession of a controlled substance case out of Kansas, in which the defendant was revoked to 20 months. In a 2013 fleeing or attempting to elude out of Kansas, for which the defendant received 5 days. I think that one is actually reflected in the PSI,
Okay,
the 5-day one.
yes.
Also, Judge, I have judgments out of Spokane, Washington for 1, 2, 3 thefts. One from 2011, 2 of them, it looks like it was a concurrent 1-year probation in 2008, and also a 2008 assault out of Spokane, Washington, in which the defendant received 338 days. And I've marked them. I'm happy to offer them.
No objection.
I don't know that I need them. I've made the notes and we'll take that into consideration as
Judge, that's all
well.
I have. I think the defendant, given his criminal history, it's a risk of sounding callous, Judge. I get it. People are struggle with drug addiction all the time. But at a certain point, Judge, there comes a point where the consideration needs to be protecting the public. This defendant's been having contact with law enforcement since 1988. And he has spanned at least 3 different states with his criminal behavior. Judge, he's fortunate to have a cap of 10. He's exposed to 20 years, Judge. I'm asking the court to sentence him to the 10 years.
$4.
I'm guilty of all that. I'm sorry.
Texas, Louisiana,
You're all right.
Kansas, New York.
I'm very sorry.
I'm sorry. Arkansas,
5, 6, or 5,
Alabama,
6.
I guess my biggest issue, Mr. Ebarbo, is, well, one of the biggest issues is I appreciate and am glad that you have done what you've done over the last few months. I think you probably started off doing that for the wrong reason, and that's because you got caught again and you're looking at 20 years in prison. It sounds like maybe you're doing better, and that's great. I just wonder why it's taken so long. It looks like you went to the Unity House back in 1986, and other than that, it's just, at some point, you've got to take responsibility before you commit an offense, not after. I've counted 24 misdemeanors. I think with some of the ones that Mr. Coleman has said, there's probably actually more than that. There were some records that couldn't be found from different states. They're probably looking at more like 30. 7 felony convictions. You've been to prison. It's just too much. And at some point, there has to be an end to what you're doing and get that help before you continue what you're doing. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 24, DCCR 1722, find sufficient evidence to find you guilty, and at this time find you guilty of theft, find your prior enhancement convictions true, sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 24, DCCR 2289, also find sufficient evidence to find you guilty, and at this time find you guilty of theft and find those prior enhancements true. Sentence you to a term of 7 years in the institutional division of the
After hearing emotional testimony about addiction, recovery, and years of criminal history, Judge Raquel West ultimately sentenced the defendant to 7 years in prison on 2 theft cases, to run concurrently. During the hearing, the defendant spoke openly about struggles with substance abuse, claiming recent sobriety and participation in recovery programs, while the prosecution highlighted decades of arrests, felony convictions, and repeated encounters with law enforcement across multiple states. Judge West acknowledged the defendant's efforts to change but questioned why accountability only came after facing serious prison time. Citing more than 24 misdemeanors, multiple felonies, and a long pattern of criminal behavior dating back to the 1980s, the judge ruled that protecting the public had to come first, closing the hearing with a firm reminder that repeated chances had already been given many times before.